April 30th, and this is Senate Natural Resources and Energy. And we've had a little bit of some changes to the agenda this morning. We're rolling with it. And so thank you to our Ledge Council for the last minute switch to be here. Appreciate it. And we have an amendment that Senator Beck is bringing, or is planning to bring, as I understand it, to the budget. But it pertains to stuff in our jurisdiction. So hopefully he'll be joining us later. But since we have you now, if you would walk us through this movement.
I'm Cassie, Office of Legislative Counsel. I sent you the excerpt so that you should have it just posted on your website, but it is also in the Senate calendar for today. This is it's kind of, it looks like a long amendment, but it does three things. The first two instances of amendment repeal the Clean Heat Standard. The third instance of amendment repeals the Global Warming Solutions Act cause of action. And then the rest of the amendment repeals Vermont's authority to use the California Clean Air Act waiver for vehicle emissions and repeals the Advanced Clean Cars 2 and Advanced Clean Trucks rule. So I'll go through that more slowly, but it's three different repeals. So the first instance of amendment repeals Chapter 94, Title 30. That is the statutory text of the Clean Heat Standard. So it repeals the whole thing. The second instance of amendment repeals the other reference to the Clean Heat Standard in statute, which is the tax data sharing provision. So currently under 32 VSA 3102E23. There is a provision that says that the commissioner tax may share the fuel tax data with the PUC and the Department of Public Service so that they can audit fuel dealer registry. So this would repeal that section as well. The third instance of amendment repeals 10 VSA 594, which is the cause of action provision in the Global Warming Solutions Act. This is also known as the citizen suit provision. Repealing this would not affect the ongoing litigation. It would be prospective. And then, so starting with the fourth instance of amendment, there's language added to 10 VSA 567. It's adding, so currently the secretary, and here this is A&R, the secretary in conjunction with the Department of Motor Vehicles may provide rules for the control of emissions from motor vehicles. However, the secretary shall not adopt the California rules for new motor vehicles authorized in the Clean Air Act 42 USC 7507. This language is then added again in the fifth instance of amendment, because there's another statute that gives the Secretary of Natural Resources additional authority to establish emission control requirements by rule, as in their judgment necessary to prevent and control air pollution. And so again, it adds the language that the Secretary shall not adopt the California rules. Finally, this language is added in the sixth instance of amendment as well, because under the Global Warming Solutions Act, there's some additional language. So section 592 for the Vermont Climate Action Plan, the Secretary shall proceed in adopting and implementing rules to achieve the greenhouse gas emission reduction requirements. However, in neither instance shall the Secretary adopt the California rules for new motor vehicles authorized in the Clean Air Act. And then finally, and so I'll just say, so there's existing, the Secretary of Natural Resources has multiple existing sources of authority to adopt air pollution control rules. And so she has them under the motor vehicle standard. She has authority to adopt motor vehicle rules, and she also has authority to adopt air pollution rules. And then she also has the authority to adopt climate rules under the Climate Action Plan, which are the emission reduction rules. And so cited in all three places because the agency has cited that all three as their authority to adopt these rules. And then finally, there is in the seventh instance of amendment, there's the rule repeal. So the Vermont low emission vehicle and zero emission vehicle rules, Department of Environmental Conservation, Chapter 40, Vermont low emission vehicle and zero emission vehicle rules are repealed. And so that is the rule that DEC has adopted for these California programs.
Yeah. Yes, go ahead.
On the rules, would this be all the rules that the secretary can adopt related to air quality and air and emissions, or,
No,
okay,
it's just chapter 40, which is the advanced clean cars 2 and advanced clean trucks.
okay, and those are part of the California rules. We've been adopting California clean air rules for decades, right?
Yep.
Okay. And if we don't have their rules, what is the fallback? What do we have?
The federal standard.
And,
And I'm sure that's gonna be good.
right, and we know who controls that.
Yeah, so there's 2 existing emission controls for vehicles, there's 2 existing standards, there's the federal standard and the California standard. And so only 17 or so states have used the California rules, the rest of the country uses the federal standard.
And could we, if we don't adopt the California, if we're not allowed to adopt it, if this passes and we're not allowed to adopt California rules, could we adopt our own rules that are more stringent than the federal rules, or no?
No.
The options are either the federal rules or the California rules.
Correct.
So there's no space for modifying the California version. Like it's either, as I'm just repeating what Senator Hardy said, but it's either California's rule or it's the federal rule. No, we're not really allowed creativity
Correct.
in that space. Okay,
Yeah, and I can just say a little bit more about how that works. So the Clean Air Act, when it was adopted, set the emission regulations for the country, and it did preempt the whole field. So all the states had to follow it, but it does have section 177 of the Clean Air Act says if there was a state as of the time of the adoption that had more strict air pollution controls than the rest of the states, that state was allowed to continue to adopt their own stricter standards. The one state that met that was California. Another provision was added to the Clean Air Act that said any other state may then adopt California's version identically. So you can either opt into the identical version of California or use the federal. And so in neither case can any state make any changes or have any creativity on that space. It's either all of California or all of the federal.
questions?
You said, and you know who controls that, you assume, I don't know.
Oh, no.
Oh.
Or his administration.
Okay, other questions, just to do some level setting here. Because we haven't really gone over the Global Warming Solutions Act in great depth here. So, this provision to repeal the cause of action. I understand that it is a citizen suit provision and not technically a private right of action. Is that, or maybe there's like an umbrella, maybe that's an umbrella term. Can you help us understand what the citizen suit provision is or what it does?
Sure, I don't think there's a distinction, I think that's,
Oh, is it? Okay, I had heard that there was a difference. I'm happy to be educated.
I don't think there is, and regardless, in the statute, it's just called cause of action.
Mhm.
And so it does say that any person can bring a lawsuit under the terms of 594 against the Secretary of A&R. And there are 2 forms of lawsuit that can take. The first is someone could bring a lawsuit alleging that the Secretary failed to adopt or update rules that would help the state achieve the requirements under the Global Warming Solutions Act. The other venue, the other option is someone can bring a lawsuit saying that the state did fail to meet the requirements of the Global Warming Solutions Act. And again, bring that with the secretary. There are specific timelines in this. It does give a timeline that first requires someone seeking to bring this lawsuit to first give 60 days notice to the secretary about what they're going to be alleging. This gives the secretary a chance to respond or potentially make changes. Then they have to file the suit with the civil division of the Washington Superior Court if they seek to go forward. And so I will say there was one after the very first deadline of the Global Warming Solutions Act where someone did bring forward a notice of violation to the secretary, but then chose not to file suit. Then at the next deadline, someone did bring a notice of violation and has moved forward with a lawsuit. So there is an ongoing lawsuit currently with the Secretary of Natural Resources under this provision. Additionally, it spells out what the potential remedies are if the court finds for the person bringing the lawsuit. So if they find that the secretary failed to do either of those things, the remedy is that the court shall issue an order directing the secretary to adopt or update the rules. But if the other way is if the court were to find that the secretary is taking prompt and effective action to adopt rules, the court will just grant them reasonable time to continue to do that. And then same for if they fail to reach the Global Warming Solutions Act requirements. The court can either find that the secretary is taking prompt and effective action to comply, or that the secretary shall adopt or update rules in order to achieve the requirements. So in either case, the only directive from the court would be directing the Secretary of A&R to adopt rules. It does, however, have a provision that says if the plaintiff prevails substantially in its lawsuit, that the plaintiff shall be awarded reasonable costs and attorney's fees unless doing so would not serve the interests of justice. Or the defendant, so the secretary, may be awarded reasonable costs and attorney's fee if the action was frivolous or lacked a reasonable basis in law or fact. So this language for this provision is based on Rule 75 of the Vermont Rules of Civil Procedure, which is why I brought this with me. And so it's been a while since we talked about this. Our Global Warming Solutions Act is based on what other states like Massachusetts have done. And when Massachusetts, after they adopted their Global Warming Solutions Act, someone did bring a lawsuit under their version of Rule 75. And Rule 75 is anyone is allowed to bring a suit for failure of a government agency to act. I'm not super familiar with some of the components of this legislation, but the rule itself is actually pretty short and a little bit vague. And so I'm making to do a little bit of research, but it's vague about what the remedies actually are if someone were to win that lawsuit. So I believe some of the intent of the legislature was this provision in 594 does put some very specific parameters about when the lawsuit can be filed and what the outcomes of it could be. I will also add that Rule 54 of the Vermont Rules of Civil Procedure. The Vermont Rules of Civil Procedure are the general court rules that anyone bringing a civil lawsuit are required to follow. So Rule 54 also says that a substantially prevailing party can ask the court to award attorney's fees and costs at the end of the case. And so that already exists in the rules currently. And so I have been asked in other committees, if you repeal the cause of action that's in statute, what could happen? So repealing this cause of action would not affect any ongoing litigation. It would just prevent future litigation. But under the terms of that statute, potentially someone could bring a lawsuit under Rule 75, and they could also use Rule 54 to then ask for attorney's fees if they were to win.
Okay. any other questions? I feel pretty clear about the first instance. Just feel like we've talked a fair bit about that, so I don't have any questions about that part, but if others do, it's fair. Okay, any other questions about this? Okay. Thank you. And we are scheduled for a break at 9:30. If Senator Beck were back, we could have him give a quick rundown of his thinking about this amendment. But he is not here, so we are gonna take a break right now, and if he's back, well, I actually feel like it may not be enough time to do him justice. And as I understand it, I don't think this is gonna be up for discussion today, as I understand it. So we have a little bit more time, so we are going to, let's assume that we'll hear from Senator Beck tomorrow. And we'll take a break from now, and we'll be back on at 10.
At 10?
At 10.